I'm joined by Harry Litman of the Talking Feds YouTube channel, the Talking Feds podcast. Make sure you subscribe to both. I'm sure you remember the last hot take I did with Harry, where we predicted exactly what Donald Trump was going to file before he filed it in the Manhattan District Attorney criminal case, where he was convicted on 34 felony counts. Donald Trump took that United States Supreme Court ruling, which held that he was entitled to absolute immunity. And then Donald Trump took that and said, look, the Supreme Court said three things: absolute immunity for core constitutional functions, absolute immunity for official acts with a broad presumption that anything I did was an official act, and third, evidentiary inadmissibility of anything that could be a core constitutional function or an official act, meaning that even if the conduct I engage in was private in nature, which Donald Trump doesn't argue in any way that the conduct involving Stormy Daniels was somehow an official act itself. He's arguing, okay, concede it. It's a private act. It predates the time I was in office. However, there was evidence that was introduced at the criminal trial about things that went down in the White House, stuff from my personal assistant at the White House, Hope Hicks, this communications executive at the White House, events that transpired in the White House to show my mens rea and my mental state. I had communications that were testified to. And he says, what the communications were. Hope Hicks testified that Donald Trump had said that, do you think things would have been different if I didn't do the payoff? And there was that moment where Hope Hicks broke down crying about this interaction that she had with Donald Trump in the White House, where she then tells the jury in this an actual Perry Mason moment, not the one that the corporate media was saying existed, which didn't, but this was the real Perry Mason moment, where she was like, and I knew at that moment that he likely made the payoff and he knew Cohen was doing it and he was aware. And then in summation, the prosecution said that was devastating evidence. You remember what Hope Hicks said Donald Trump told her in the White House? That was devastating. So now Trump saying, you say that was devastating, that's therefore prejudicial. The Supreme Court says that is the type of conduct that occurred while in office. We're not saying that's the criminal conduct. We're just saying that's just conduct that happened while you were in office. That should have been excluded. None of this stuff should have went before the grand jury. None of this stuff should have went before the jury. And now Judge Merchan dismissed this entire case because it was tainted by this. I want to get you, break it down. I mean, what's your take on it? What do you think is going to happen?
55 pages, and it's exactly, I do have to say, Ben, we pat ourselves on the back accurately because we led with what they were going to do. None of this, they're not saying that he was tried or convicted for official conduct, but it was this extra little, minor sinkhole that the court put in there of you can't even use the evidence. So that's what he's doing again and again. I want to get a little bit on the nitty gritty because Hope Hicks has got sort of a two-part argument because you're right. She breaks down on the stand and they're going at why it's devastating. But also before that, he says, this is official conduct. This is kind of like the court said when he was talking with DOJ. That can be as brazen and lawless as you want, but they sort of give it the category of what Article 2, what a president decides on investigations, roughly speaking. In the same way, he's first saying Hope Hicks is just an official top line thing. Therefore, goes the argument, no harmless error analysis, because that's where the action's going to be, I think, in the Merchan court. Hope Hicks probably shouldn't have gone in there. Of course, no one would know that because nobody expected the crazy, complete reordering of the law that the Supreme Court did. But a lot of it, I was there. A lot of evidence. Other than that, so the question will come down to: is it harmless error or isn't it? I think that's the way it'll probably go. But we have a similar argument for, as you say, Madeline Westerhout, his assistant, and the keeping of the, why she was used is to show Stormy Daniels is in the Rolodex. But he wants to say, well, this is just official secretarial function and the like. So he first wants to even get out of any kind of presumption, or he wants to say this is just completely hands off. I think the interesting thing here, and we're gonna hear from Bragg, I think in 12 days, but I think Mayor Chun, very thoughtful, solid judge, and I think he will likely say, "Come on," because take a step back. This is, you can't imagine sort of more unofficial conduct, more the sort of thing one doesn't need. You shouldn't get immunity for. This is as personal as running a crap game in the Oval Office. But the question is, will Trump be able to immediately, before anything happens and even before he is sentenced, that'll be he wants to avoid having it pronounced on him. Will he be able to appeal it? And that would first go to the appellate division, the middle level in New York, then possibly the top, and then possibly his buddies at the Supreme Court who could reach down and slap whatever happens. So look, this is a case that if Trump can get rid of this incredibly unofficial conduct, mostly all before he's president, man, then there's nothing he can't wriggle out of. And I think he shouldn't be able at the end of the day. The game, though, is will he be able to forestall having sentence pronounced or just gum things up with appeals? Because this is immunity, and that's how we got to the Supreme Court early in the first place. Will he be able to do that before November? That'll be his game. And Mayor Chun isn't the last story when it comes to that, deciding whether that succeeds.
So what would likely happen, no matter what Justice Merchan does, Trump would initiate some sort of federal action under the Supremacy Clause, while also potentially simultaneously going to the appellate division as well. I mean, he would do everything. He's going to throw.
That's a good point.
all the
That's what he
money.
does with Eileen Cannon, but he can just keep appealing. Boom, each one will take another, but a separate federal action. Interesting, yeah.
Well, I'm not, knowing what his MO was before, it's hard to imagine that he wouldn't throw all mud against the wall. But you mentioned a doctrine there called harmless error versus reversible error. So that analysis would be, there was so much unofficial conduct here that Hope Hicks saying this, that, and the other, or Westerhuis saying this, that, or the other, was not the thrust of what this case was about. The jury would have come out the same way anyway with the overwhelming evidence. And in any event, that type of conduct under a separate analysis would still be private conduct. There's already a factual record. We don't even have to, even if we don't view it as reversible error, you could argue there was no error at all. They were talking about the conduct, talking about criminal conduct that predates your time in office is not the type of anything that should get any presumption at all of being an official act, even if it's happening in the White House.
That's right. Just like signing a personal check, right? Which he did here. Personal check, he's president, but that's not official conduct.
I mean, to give you a drastic example, if Donald Trump called in a random person into the White House and shot him, and then said, hey, this was my role as the commander in chief, would the Supreme Court say that's a core constitutional function, part of your official acts, or would that be private? I mean, here, talking about hush money payments to porn stars where you falsified business records relating to that, does that even get any presumption of official act? So that's an important concept that I think will be addressed by Justice Trump. But I think what's interesting about this discussion as well is Trump's been saying over and over again, rigged, the trial's rigged, Justice Merchan's daughter, wah, wah, wah. This case went before first a grand jury, which issued the indictment. Then it went before an actual jury. And after weeks of trial, hours of deliberation, a jury, the way our system is supposed to work, found that Donald Trump did it. That's the system. Justice Merchan didn't find that Donald Trump did it. A jury did, and then a grand jury indicted. Then Donald Trump runs to the Supreme Court, which issues a ruling that goes above and beyond what Trump even asked for, to add this concept of evidentiary inadmissibility, seemingly related to the New York case, but adding this concept and then basically saying, you know what, screw the jury, screw the people, screw the grand jury. We're going to provide cloaks of immunity. And that is, to me, the part that was so antithetical to the system. And as a former lawyer, the idea of a jury system is so sacrosanct, in our process. The idea that that could even be ripped away by, unelected bureaucrats on a Supreme Court or elsewhere that to me is the scandal.
And that last part, actually, Justice Barrett agreed with you. And what they have to say? The whole thing, by the way, they call it a separation of powers analysis. It really isn't. It's just their idea of what makes for a nimble, effective president, or a king, as you put it aptly, Ben. But this, though, that last principle that we're now focused on, and he's trying to use to get a new trial. They just sort of, lopped that in. Well, if we let him have evidence, it would undo the immunity. No, it wouldn't. Official actions people find out about all the time. They just, sort of, here's a little extra gift you can use. And it's the whole game. Again, I think at the end of the day, he doesn't get a new trial in New York. But of course, at the end of the day is after the election, as with so many other things. I think the way you put it is, it's down to us.
Justice Merchan, from a scheduling standpoint, though, I think did the right thing. He pushed the sentencing to September, has this briefing now so that the sentencing wouldn't get, in theory, delayed by the briefing. Push that sufficiently in advance, let the parties fight over this issue, hold the hearing. And then that's why Justice Merchan, if we're going to sentencing, then it'll be boom, right around the corner after this issue sorted out. And even if Trump tries to do emergency appeals or whatever, you still have that September date versus Trump trying to argue that there's some urgent date that's going to happen tomorrow. So you let that process play out. And so, there's that behind the scenes move that Merchan is doing. And look, this is a law and order.
I'll just summarize quickly. The maneuvering, he doesn't want the country to hear Justice Merchan, chastise him and pronounce sentence, and show the majesty of the law coming down on him. That's what he wants to avoid, and he's using these things to try to delay and move things around. That's the sort of upfront drama that is cloaked in the whole immunity motion.
Well, everybody, please make sure you subscribe to the Talking Feds YouTube channel. They do detailed breakdowns multiple times a day, led by Harry Litman. Please subscribe there. They're on their way to 300,000 subscribers. Want to get you to 500,000, though, by the end of 2024. Keep building pro-democracy channels like that. I'm with all of you, Meidas Mighty. I've been let down by a lot of media over these years, and I think it's important that we just get facts and details. It may take a little longer than 30-second sound bites, but I promise you're going to get all the real info, real details, and understand this system. Again, go right now, subscribe to the Talking Feds YouTube channel. Have a wonderful day, everyone. Thanks for watching.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.